The Department of State Services will arraign former Kaduna State Governor Nasir El-Rufai before the Federal High Court in Abuja on Wednesday, February 25, on charges of cybercrime and breaching national security. The DSS accuses El-Rufai of unlawfully intercepting phone lines belonging to National Security Advisor Nuhu Ribadu, violating the Cybercrimes Amendment Act 2024 and Nigerian Communications Act 2003. The case was assigned to Justice Joyce Abdulmalik by the Chief Judge, John Soho. Jide Ologun is a legal practitioner. He joins us in the studio for this conversation. Thank you very much for being here. The DSS has filed a 3-count charge alleging unlawful interception of the National Security Advisor's communications. What specific elements does the prosecution have to prove for conviction to happen?
The charges are clear, and what the law says is that these allegations must be proved beyond all reasonable doubts. And of course, there are 3 canons in criminal justice ecosystem for effective justice dispensation. You need thorough investigation, and I believe that has been done, particularly when we already have some admissions from the defendant himself. And then you now talk about diligent prosecution, and that is where the problem lies most times, before a committed judiciary. So it's between these 3 elements, and I guess that following the investigations, arraignment was prescribed, because right now the matter is going on prosecution. So let's see the kind of diligence that the prosecutor we give to the matter, because under the Nigerian Constitution 1999 as amended, he is still presumed innocent until the allegations are proved beyond all reasonable doubt.
The second count is accusing him of knowing of an interception, but refusing to report it. Can mere awareness without active participation establish criminal liability, or is it a demonstrable criminal intent required?
Like I said earlier, these are allegations. So, and of course, he will be given the privilege of having his defense team to break down the allegations of the prosecutor. So it's up to him to either admit, and when he is arraigned, he will have to plead to the charges, whether he's guilty or not. And if he pleads not guilty, then the prosecution will proceed. So right now, it's the state against El-Rufai.
Expectedly, he would want to defend himself. So what are the...
He must defend himself. I don't expect that he will go the way of Nnamdi Kanu. Unless, you see, the concern of citizens now is perhaps his political status. But if you look at Section 1 of the Nigerian Constitution 1999 as amended, it states clearly that all citizens are subject to the Constitution, even the president of the country. That is the prevalence of the rule of law. And when he was a governor, he was entitled to immunity under Section 308 of the Nigerian Constitution 1999 as amended. But right now, he's no longer a governor, so he should be answerable to the law. But that is another issue entirely. And my concern is this issue of prosecution. If you look at the case of the former governor of Ekiti State, Ayodele Fayose, he was also arraigned in court. The matter went on for 6 years. At the end of the day,
so what implications should we interpret here beyond the legal dimensions to the conversation?
Some we want to say it's politically motivated, but even political considerations are subject to the Constitution. And that is why I made reference to Section 1 of the Nigerian Constitution. And you see, if you look at Section 15, subsection 5 of the Nigerian Constitution 1999 as amended, it says that the state shall abolish corrupt practices and abuse of office. Because in the case of El-Rufai, he also has a case with EFCC bordering on misappropriation of over 400 billion naira. His aides also are being taken up on, inappropriate mismanagement of funds. So the big question now is, should we condone corruption in the land? So for me, I won't look in the direction of political, platform. No, let the law have its way. But he has the privilege of defending himself.
Okay, just this quick one for educational purposes. What are the procedures for obtaining warrants or authorization for phone tapping in Nigeria? Is that even legal?
We have the Nigerian Communications Act of 2003, and of course, the procedures are clear. But interestingly, and that is why, as a public relations practitioner, I should advise the high-profile personalities, be trained on the information you release. I mean, you don't need to impress the people. And here is a big one for him to manage, because the DSS that was set up as far back as 1986 is out there to ensure internal security in the country and to ensure that we don't jeopardize our security apparatus. So even if he was acting under political consideration, you must have deep respect for legal procedures.
Yeah, one thing is to have these cases being brought up, but another thing is to follow through. What are the chances that we'll see the end of this?
That's why I mentioned the case of the former governor of Ekiti State, Jide Ologun. He's been released, and I doubt if the government is appealing that case. Right now, Mallam has, had to forfeit in the interim properties worth about 213 billion naira. So in law, we say there's a prima facie case against him. But who knows whether he'll be released after some backdoor meetings. And then Emefiele is still there. Even former Governor Dariye, whose conviction was confirmed by the Supreme Court, eventually got a state pardon. And that's why I had to knock the head of Section 15, subsection 5 of the Nigerian Constitution 1999 as amended, that says the state shall abolish. And if we know the grave impact of corruption on national development, then we should be serious about corruption. But there are several cases pointing to the fact that Nigeria as a country may not be serious about fighting corruption. So this is another one we are monitoring to see how it goes.
Thank you very much, Jide,
for obliging
us.